It's time once again for another episode of Atlanta Legal Experts Radio, broadcasting live from the Pro Business Channel studios in Atlanta. And now here's your host, Emily-Rowell.
Well, Emily is not here in the studio.
Under the weather, right?
Yeah, a little under the weather, yeah. And there's a lot of weather going on out there, yeah.
Yeah, liquid sunshine.
Nice. So, Rich Casanova here for Emily-Rowell on Atlanta Legal Experts, and alongside our co-host this morning, Craig Williams. And you sound chipper today for a Tuesday early morning.
Always, man. Tuesday? Is it Tuesday?
Yeah, I think so.
No, it's autumn.
Oh, yeah, nice. You're all about evergreen, right?
Yeah,
so when we listen
exactly.
to it. Yeah. So only listen to the show on Tuesdays, and then you're good.
No.
Yeah. So we're live right now, broadcasting from our Pro Business Channel studios here in Buckhead. Have some great guests in the studios. They are absolutely always subject matter experts.
Yes, Francis Cullen, known as Fran.
Yes.
And we also have Barton Black. Black, tell us a little bit about what we're going to hear today.
I'm going to discuss the non-compete and restrictive covenant area in Georgia as the landscape is ever-changing, especially in the past few years.
Wow, that's going to be exciting. That's going to be real exciting, Rich. Non-compete.
Right, exactly, yeah. There's a backstory to that. We don't have time for that show right now, but yeah. But that's a I'm sure listeners as well as myself will be tuned into that one, because that's a big challenge for businesses, whether they're franchise or partnership.
Technology especially.
Yeah.
When you have the coders and they're doing a lot of the legwork.
All that secret sauce, whatever. Intellectual property. We'll be touching all that, I imagine, right?
Yeah, that's going to be exciting.
Okay, so let's go ahead and do the formal introduction for our first guest, Fran, joining us in the studio.
Yeah, we have Francis Cullen with Francis Cullen PC Legal Services. She hails from, where do you hail from?
I am a Brooklyn girl.
Oh. Wow, I love New York. Wow. How long have you been here?
We're not telling.
Okay.
So not Brookhaven, but Brooklyn.
Oh, Brooklyn.
New York. Yes.
She and her attorneys at Cullen focus on their legal practice on the representation of professionals in administrative, criminal, and civil matters. As former prosecutor and former assistant attorney general for the state of Georgia, and with more than 20 years of representing professionals, say that 3 times, in licensing matters before the Drug Enforcement Agency and in the criminal court, Francis Cullen has the specialized knowledge and experience to provide sound guidance to professionals facing legal issues that could affect their livelihood. Our practice, or her practice, not mine, her practice focuses on...
Want to join?
Yeah. If I could read off this thing with a glare. Our practice focuses on the representation of healthcare providers, but it represents all other professionals in the administrative realm. Her firm is unique in, I guess I'm going to be joining you. Her firm is unique in that they try and understand the entire scope of issues and potential ancillary consequences a professional might face when a complaint is lodged against their professional license. A question arises regarding prescribing oh my goodness, guys, y'all got to help me out with this, but the Drug Enforcement Agency or other professional regulatory body, that's a lot. Francis, can you give me the cliff notes of that?
I represent, there are over 50 professions licensed by the state of Georgia. Most people, when they think about it, they think about their doctors, dentists, psychologists, nurses, but there are over 50 professions that are licensed, and it is a separate body of law that regulates that, which is administrative law. With healthcare professionals, there's different code sections and different laws and rules from other areas that impact how they regulate what they do, and there's lots of impact from any potential action against them, especially healthcare professionals, which are also regulated by Drug Enforcement Agency, could have impact with Georgia Drugs and Narcotics credentialing, and our firm specializes in that kind of, or concentrates on that those types of issues, because we have a complete overview. We also represent people with criminal cases that could also impact their livelihood, because if you need a license for what you're doing, having an unencumbered or a free and clear license is very important to your profession.
Operate.
Your daily life, making your living.
So your name's on the front of it, of your firm. Before you started your firm, did you know that this was the trajectory you were going to take in the future? Or?
No, I was just chatting with Barton and telling him how I worked for... I was a prosecutor with the DA's office. I was at the State Attorney General's office on the other side of this niche practice. And I went into private practice almost 20 years ago in this building.
Wow.
And it took anything, an eviction case, a divorce. I did, but because there was no one specializing in this or concentrating on this area, the cases started coming to me, and the practice grew, and my scope of knowledge grew, and I got to know more people in the field. I have a lot of contacts. This is the kind of area where it's knowing who you reach out to and what are the resources to give your clients the best outcome, or solve a problem. I think of my firm as a problem-solving firm.
Exactly. That's what we love here at Pro Business Channel, is that the true entrepreneurial spirit lies in the hearts of those who sit across from us on a weekly, daily, and monthly basis. And just hearing your story, I heard that evolve. It was the problem. There was a problem, an underserved group of people who needed to be served.
It's interesting because when I first went into practice, I had been representing a lot of people who had been through treatment centers. I had prosecuted them on the other side. And then the treatment centers started calling me and I like to think it's because I was fair as a prosecutor.
Of course you were.
I did my job, but I tried to look at the facts. People are people make mistakes. And I started getting calls from them because they didn't know who could represent these people and look out for their best interests. And then I started learning about also all the different effects that any of these actions could have. And that's how my practice grew. And I think it's because I really try to protect people's interests all around.
So that entire scope of practice is, since you've already worked with some of them on the other side, and now you may be in front of them on the other side.
That's correct. Yes.
Do you relapse to the other side sometimes when you're... Or, of course, that experience helps you to serve them better, I assume.
I think it helps to serve my clients better because I know the process, I know the people, I know how the system works, and I think it's also about relationships.
Yeah.
There's a lot of people who I worked with at the state that I still call on as a resource. We think of ourselves as respectful colleagues, even though we're on the other side, maybe on the other side of a fence. I also think if you're good lawyers try to have the best solution for their client, whether or not it is the... I don't have to be the bulldog all the time.
Gotcha.
It is working with the other side to see what is a reasonable solution.
There is some compassion and apathy and empathy in some cases. If a professional is faced with a complaint by the license board, how should they respond to that inquiry?
Very respectfully, for one, and that's not always the case. I gave a talk on this just the other day, but I recommend someone reaching out to a lawyer only because it's your only advocate and it's the only person who could go with you before a licensing board and could be your witness. I always also say it sort of puts the boards on better behavior if you've got someone with you. But it is really to be thorough, be honest, but also don't volunteer. Complaints are confidential by law, so it's an odd minefield that you can walk through. You may have a complaint lodged against you and not know who filed the complaint, what the complaint was. Don't guess too much and wait to find out what you can. But be honest with investigators, be prompt. If they subpoena records, give them the records in a timely manner. But it is really good to seek assistance.
So what if a complaint is lodged at a fire employee or an ex-spouse?
Happens all the time.
How does that impact the actual inquiry?
It's interesting because most of the licensing boards look at it as we don't care where the complaint came from. If there's validity to it, we're going to continue looking at it.
Yeah.
Unfortunately, and it seems the majority are former employees, bad employees, and I know Barton does some work with employment, but a bad employee.
It's probably going to continue to be a bad employee.
People who are vengeful will file complaints.
It's their character.
And the boards don't seem to care much. They will look at whether there's validity to it. And so I have seen people who write their own responses to a board complaint, because some of the boards will ask them to write an explanation. And some of them will write something that says, this was a bad employee and she's just mad at me. And no, answer whatever the issue is, because they don't really care.
Yeah. Well, folks, we have Frances Cullen, PC, known as Fran in the industry. Her legal practice is a representation of professionals in administrative, criminal, and civil matters. So keep that in mind in the back of your file, or in the front of your filing cabinet there.
That's right.
Yeah, that's right. So once again, if a professional receives a letter from a licensing board, what steps should they take to protect themselves?
First of all, pay attention. You would be amazed at how many people leave those letters sitting till the last day.
Like another bill, right?
Yeah, like a bill, right? Like,
does it come in a different color?
There must be a late fee on this. It doesn't. It doesn't. It sometimes just comes in a letter,
Yeah.
And pay attention. Pay attention. There are deadlines. And respond in a timely manner. And if you have to step back and think about it, just ask for more time.
Gotcha.
Don't ignore it. I have seen people lose their license by ignoring notices.
Wow.
So pay attention, be respectful, reach out to whoever's written the letter, find out what it's about, find out what you can, and don't over-volunteer information right away.
Gotcha. And you said some of them could lose your license, so that's one way, by not responding in a timely fashion. That's one way of losing your license.
Correct.
If you go through the process, could you lose your license just because you weren't as agreeable with the process, or unless you went against something that you should not have gone against?
There's a process. Licensing is considered a limited property right. And it's limited. You have due process, but it's limited due process. So if you hold a license, you're entitled to a hearing. An applicant for a license has almost no rights. The boards can turn you down for any number of reasons if you are seeking a license, and they can apply strict rules. But for people who hold the license, there is a process, but you have to respect the process and engage in it. And there are people who don't show up to hearings, don't respond to pleadings, and that is a way to lose your license.
Yeah, so this license is not an inalienable right.
No, in fact, it's considered a privilege and not a right. That's exactly right.
Yes, I'm glad to hear
that.
The Drug Enforcement Agency, what is your regulatory role with that?
Drug Enforcement Agency in Georgia, the pharmacy board is we have a state enforcement agency, which is Georgia Drugs and Narcotics.
Say that 4 times.
Yeah, that's my tongue twister for this morning. And they do most of the regulation. In some states, there is no state enforcement agency, and that would be the Drug Enforcement Agency. But the Drug Enforcement Agency, any healthcare professional who has prescribing rights will have to have a DEA registration. Your doctor, some advanced practice nurses, physician assistants, dentists will all have a DEA, and that also has to be protected. And there are certain things that can trigger an action by the DEA.
Yeah.
That is a federal agency, and there is a certain body of law that governs that as well. But Georgia Drugs and Narcotics regulates most of Georgia and regulates the pharmacies and most of the prescribing here in Georgia. Yeah. And they are a very good enforcement agency, although the DEA in other states, and I've done cases with co-counsel in other states with the DEA bringing the action against those types of professionals with prescribing rights.
Okay. So let our listeners know how we can contact you, and let's hear about your social media links and the such.
Okay. Well, I have a website. It's www.francullen.com. So it's not Francis, it's francullen.com. And you can email me at fran@francullen.com.
All right, want to remind our listeners you're listening to Atlanta Legal Experts radio show. Rich Casanova here alongside Craig Williams, your co-host for today. And we're having a conversation with Fran Cullen. And up next, we have Barton Black with Barton Black Law, LLC. We want to remind our listeners this is brought to you in part by Peachtree Offices here in Buckhead, as well as other locations throughout Atlanta, and also a 3A Law Practice Management, and as well as Atlanta's John Marshall Law School. You can find their information on the website, atlantalegalecexperts.com. And we're going to now turn our attention to our next guest joining us in the studio.
Barton Black, sharp jacket once again, man.
Thank you, Craig.
Sorry, listeners, you missed out on that one. But you could go to our website and look at
for the photos.
As a matter of fact, I think they sent each other an email because they're working that collaboration with the gray going on. I love it. Okay, Barton Black is a founder and managing member of Barton Black Law LLC. Barton maintains a diverse business practice, primarily representing small businesses in commercial and employment litigation. Barton's litigation focuses on non-competes, restricted covenants, employment HR issues, business disputes, contracts, collections, and intellectual property. Barton also represents individuals in disputes involving non-competes, employment discrimination, wrongful terminations. We talked about that earlier. Overtime pay and contracts. You might need to talk to him about that overtime pay over there, Rich. And contracts, collections, for example. Barton experience includes work in large and small firms and handling issues that have local, national, and global reach. Barton, welcome to the Ale Show, Atlanta Legal Experts.
Happy to be here, Craig.
Tell us a little bit about your journey from Austin and Bird, man. That's I'd like to hear about that one. I know a lot of those guys over there.
Sure. I started off in the summer associate program after my second year in law school. I was fortunate to get a job with them, and actually started off in a patent prosecution role where I drafted and prepared patent applications in the mechanical and IT space. I was an engineer undergrad, and so it was a natural fit to go into patents. Did that for 2.5 years and wanted to move into more of a practice where I got to interact with clients, other attorneys around town, in the community, and so I progressed into litigation.
Gotcha. And at KPMG, tell me about, was there a transition there?
Before law school, I was a consultant for KPMG, traveled around the country and represented folks with information technology audits and consulting.
But what's interesting, because I was a co-founder of a technology company once before, and we had a trademark, and it was infringed upon a big name in the let's say the podcasting industry, and it was an IP. One of our IP attorneys is the one that found it, and that was an incredible journey. So, I mean, you do a lot of research, a lot of research constantly, right?
Absolutely. And trademark infringement cases can be exceedingly expensive. I think the average case is $750,000 on both sides to litigate it.
The other side of ours, they said, why don't you just fly up here to New York and let's talk about it, because I'd rather give this money to a nonprofit than to attorneys. So I was sorry about that one. So what are the restrictive covenants and non-competes?
Restrictive covenants are generally a contractual form that helps a company protect their goodwill, their IP, their customer base. And they take the form of non-competes, non-solicits, and trade secret protections.
Are there always like time limits to that, or is it just, hey, you're not going to compete with me forever, right?
Yes, in Georgia especially, there have to be reasonable time limits. 2 years is now generally the time frame for an employee, non-compete, non-solicit. For restrictive covenants that come along with the sale of a business, it's frequently the buyer of a business will want to make sure the seller can't go out and start a new business. You can have up to 5 years generally, but 2 years is the rule of thumb.
So it's not a regional type thing, or like, certain laws where the city or the state controls. It's a blanket.
It started off as a reasonableness analysis, but it's evolved, and now there's a statute, New Restrictive Covenants Act, that sets 2 years as the maximum time frame for an employee non-compete.
So what about that do you enjoy the most?
On the employer side, I love helping out entrepreneurs and small businesses who they create their business and they need to protect their customer base. They need to protect their secret sauce. So if they have salesmen, saleswomen out soliciting customers, they need to make sure those folks aren't just going to be able to leave and take the customers. So I like, as being a fellow small businessman, I enjoy helping them protect their businesses. And on the employee side, I like helping out folks who they want to make a living as well. And so I can help them navigate the minefield of their restrictive covenants and figure out where they can branch off and where they can lawfully go start a new business.
Certainly a hot topic in Georgia today, right?
It is. With the new Georgia Restrictive Covenants Act in 2011, it's a whole new playing field. Before, Georgia was very hostile toward non-competes, non-solicits, and it was very challenging for an employer to even be able to restrict an employee or to enforce a non-compete. Somebody would leave, they would go to court, and the judge would invalidate the non-competes very frequently. And so there was a lobbying effort more so. Chamber of Commerce was looking to make Georgia more employer-friendly for enforcing non-competes and to bring it into consistency more so with the rest of the country. And so they passed an act in 2011 that's given courts the ability to, I'll say, reasonably modify a non-compete or non-solicit so that an employer actually can enforce it and protect its business.
Gotcha. Sort of like we were just... the South is so hospitable, right? So that I guess they were more hospitable to the employees than the employer. So I get that. What does that mean for the employees, though, all the way through?
For the employees, they really have to make sure that what they are signing is something that they're going to be able to live with, because these days anything they sign is more likely going to be enforced.
Yeah.
And in Georgia, an employer can force an employee to sign a non-compete so long as they fall within the category of employees who can be restricted. It's not duress. It's not coercion. The employer can say, hey, here's a new non-compete. You need to sign this to continue your job.
Gotcha. So like Fran was saying earlier, open it, read it, so you know what you're signing. Because I know when we start our new professions, we're just excited. Oh yeah, whatever. Just but read what, as an employee, make sure you're reading what you're signing, and if your job depends on it, that's part of the deal. So keep that in mind. Can an employer keep you from working at any other job?
No, an employer cannot pin you down into your only job. The non-compete or non-solicit has to be restricted in time, territory, and scope. And so if a non-compete says that you can only work one job 24 hours, 7 days a week, that's going to be invalid. There was a recent Georgia case that just came down, and a contract that just appeared to harmlessly say you need to give your full time to this job was deemed to be a 24-hour, 7-day-a-week restriction. And it was completely invalidated. And so that employee was free to compete and do what they wanted.
Wow. Again, remind our listeners you're listening to Atlanta Legal Experts radio show alongside Craig Williams, Rich Casanova here, and brought to you in part by Peachtree Offices, 3A Law Practice Management, and Atlanta's John Marshall Law School. So we also do a couple of shows in here, franchise business radio, for example. So in terms of a non-compete, what are some typical kind of structures or limitations? What are they typically looking to incorporate in that? As far as is it a time period or geography involved, or product names or brands, or what are some on the short list of those?
Sure. Well, in the franchise space, the intellectual property and the trademark and the territory are going to be the primary concerns. And for any non-compete, or any franchise agreement, it's going to have the similar restrictions in Georgia that it has to have a time. It's going to have a territory. So at the franchise, maybe you would give particular counties, a particular state, and you would grant a license to use the trademark in that region for a particular amount of time.
Now, could they say, I mean, it's obviously state by state, but if you're operating a franchise for a couple of years here in Georgia and you decide, well, I'm going to take this on the road and replicate the same services minus the brand name and trademark, but in California or Texas or New York, can they limit, when you say territory, is there boundaries? Can they say you can't do this in any 50 states for 2 years, or?
They can, a franchisor can reasonably limit the franchisee in territories, in time, and where you can use the trademark.
Wow.
So if you have a McDonald's franchise in Georgia, you probably can't just go start California, Alabama, Texas, and go take it somewhere else unless McDonald's contract allows you to do that.
Mm-hmm. Right. And what about, what type of folks do you normally deal with in your practice?
I deal with anybody from medical professionals to retail and service companies, garage door companies, electricians. They want to limit their sales folks from being able to take their customer list and go start a competing business. Mm-hmm. And with medical professionals, if a practice has several offices around the Atlanta area, they want to make sure that their physicians can't go start a practice and then all the patients leave.
Right. And is there a typical range of when you engage with someone? How long does that process take?
The process can be as quickly as a few hours.
Oh, yeah.
If they sometimes an employee may face an injunction hearing.
Okay.
They've gone out and started a new business, and their employer sees that they're out competing, and the employer can run to the courthouse, file a motion for a TRO or an injunction, and all of a sudden the employee may have a hearing in the next couple of days. So you can have to be hired and vet your clients very quickly. You may have a longer courting process,
right,
which you solicit employers and earn their business over a few weeks and then enter into hopefully long-term engagement.
And if there is, do you ever engage where there's not a built into the contract a non-compete clause where obviously trademark and name, you can't go out and do the exact same name, but if it's under an affiliate or a licensee arrangement, and or maybe a franchise, but typically franchise agreements always, I would imagine, incorporate the non-compete. But if there is none in place, is there kind of some gray area where a client might ask you to step in and say, "This is so close to exactly what we were doing"? Yes or yes?
Absolutely. Absolutely. Anytime, a former employee leaves, typically in that situation, it will be maybe a co-founder or an executive for a company.
Right.
They may not have a non-compete.
Right.
There are some other laws that can protect the company. There's the Georgia Trade Secrets Act, and pretty much every state has a Trade Secrets Act. So if the customer takes something that is protectable, such as a customer list or the secret formula, the classic Coca-Cola trade secret, then there are other remedies. There's also breach of fiduciary duty if you are high enough up in the management, or if you're a salesperson who is out dealing with customers day in, day out. There are some alternative remedies if there's not an enforceable non-compete or non-solicit.
Let's say you were the secret sauce and you left. How does that work?
You have to prepare for battle. In that case, I mean, somebody like Coca-Cola would absolutely, come after the handful of folks I think who know the secret formula. And so you either want to save up money, prepare for litigation. You can, typically it's not something as that's probably about the most valuable trade secret in the world. But typically, if you want to leave and customers and the ins and outs, it depends on your relationship with your boss and the employer. You may negotiate.
What about statute of limitations? Can a company come back and say, okay, we kind of fell asleep, or we ignored, or we were for a period of time, but then fast forward down the road, we're going to decide to take action here?
Well, on a written contract, if there's a written non-compete, it's 6 years.
Oh, really?
Now, that doesn't mean you can go after 6 years of competition. You could go back and if you learned 4 years after an employee left that they had stolen a customer list, then you could go back to, maybe the 2 years of the non-compete and realize, wow, they stole, they competed against me for 2 years and took what I think are my rightful profits, and you could go back and pursue those, try to disgorge those profits.
Now, you brought up this customer list a number of times. So in most businesses, unless it's we're dealing with high-level, secret, classified information, government type
formulas,
right? Yeah, but in terms of the client list, if that client list is very protected, but many times, that's public information. Those folks are out there on LinkedIn, on social media. Unless you're exporting that client list, is there some gray area there of these folks are very easily accessed, but is it because they've done business with that company? Here's 100 people that their information's out there, but they happen to have done business.
Well, it absolutely is a gray area.
Yeah.
The customer list can only be protected primarily if it's kept in a certain arrangement. It's kept under password protection, for example, on a computer. Maybe it's the customer list that you print out of, your QuickBooks accounting or your Salesforce, customer relationship management software. It's not the name of the customer, their information generally, because like you said, it's public.
Yeah. So if, say, Craig and I are doing business and we expand into other markets and we're thinking, well, Barton was a great guy, so I decide I'm going to reach out to Barton. But you can't just categorically go abscond the entire list, is what you're saying.
Exactly. You can't you can't press print, print out the customer list from a locked down system
makes sense.
Yeah. But now a customer non-solicit may prohibit the employee, though, from soliciting the customers, even if they just generally know them. If it's your neighbor that you're doing business with, you may not be able to do business with them anyways.
It's all what's up front. Like you said, you got to review the paperwork.
Yeah,
up
you
front.
got to open it up first.
Oh yes, yes.
Yeah, Fran says you got to open it. Read your mail, please,
and your email too.
I know it's antiquated, but
exactly. All right, so we got a few more minutes here. We're going to finish up a little questions with Barton, but we'll also open it up to a panel and any final comments here as well. So, Barton, what are some challenges that you typically experience with dealing with folks, and how do you acquire new clients?
Sure. One of the biggest challenges is employers having non-competes, non-solicits that are old and stale. And so the law is ever changing. And they'll have an employee who came to work for them 20 years ago. And then that employee will leave, take customers, and they come and say, hey, we want to go after this employee and make sure that he or she cannot compete with us. And you'll look at the non-compete, and it's based on law from 1992. So that's one of the selling points is, hey, employers, you need new non-competes, especially now with the new law. So persuading employers and informing them that there is a benefit to be gained now by going out and signing your employees to enforceable non-competes and non-solicits is one of the best ways we get new business.
And probably quite a bit of that updating is like you're talking about the technology implications as well. So how often should an employer revisit those contracts? I
would say every 5 years at the most.
Okay. Yeah, so it's not an annual thing.
It doesn't have to be an annual thing, but as an attorney, we want to, as Fran probably does as well, we want to keep our clients updated on changes in the law.
Yeah.
And so it may end up being, in February of next year, a new case comes out.
Yeah.
And we'll send out a client blast and inform them, hey, how about you look at your non-competes and we'll take a look at them and update them for you.
I'd see that especially in the technology.
Well, especially if you have that new case that sets a precedent, that it can be a game changer across all platforms. So let our listeners know, Barton, what's the best way to reach out to you?
I've got a website. It's Barton, Barton, blacklaw.com, and I'm on LinkedIn as well.
All right, perfect. And so any closing, if there's any closing comments or questions, but otherwise, maybe we'd like to always kind of switch gears and ask our guests, what do you do when you're not wearing your legal hat? What's your, where do you go to be inspired, or groups you volunteer? We always get this deer in the headlights look for entrepreneurs, because there's never an off switch on for business people, right? But do you have a travel or family, or what do you?
It's tough as a small practice to yes, have enough free time. When I have more free time, I like to kayak.
Oh, okay.
Up in
so do I.
Really?
Yeah.
Yes.
North Carolina, Tennessee. I like rivers, but I also will do Gulf. I have had to cut back, and so I've gotten. I only do easier rivers now. I've gotten kind of lazy with dragging the boats.
Are you a winter kayaker?
No. Look at me. I'm thin. I mean, it's like way too cold out there. Yeah. No. I try during the summer. This past summer, I had a case that I actually had a case abroad. So it's like I was just too tied up with work this summer. This is the problem with being a small practice or solo, and didn't have enough outdoor time. But I like the outdoors. I like to hike. I like music festivals and kayaking, and I'm an in-towner, so I really take advantage. I'm right on the belt line. I cycle on the belt line, walk on it, and
Nice.
Yeah.
Cool.
Yeah.
Cool.
An outdoor enthusiast. So where did that take you abroad?
I had a credentialing case. Had a case with the military. It was a credentialing case, and it was a military base in England. It was fascinating.
Yeah. No.
And we got the first round decision, and then it has to be adopted. So we're sort of still in process, but we got a good result for the level we litigated on, and it was a fascinating experience.
And what part, how long, and had you been there before? That's a 3-part question, yeah.
Well, yes, I had my senior year, I went to the University of Sussex in England. Yeah. I've been married, and my first husband is British. Okay. So I've spent quite a lot of time in England, nice. And it was nice going back. I did not get to revisit familiar haunts, but the hearing was at Lakenheath, which is a famous military base. It was very important in World War II. And that was near Cambridge. Okay. And then did get to travel around, spent some time in London, in Cambridge, and in the Cotswolds. And it was lovely. It was beautiful.
Well, next time you're over there, we'll have you call in on our international business radio. Yeah.
Okay. All right.
Just have to keep an eye on the time zones, but yeah.
That was a good experience.
And let our listeners know one more time your website. And
it's www.francullen.com. And you can reach me at Fran@FranCullen. And I'm also on LinkedIn as well as Francis Cullen. So, yes.
Okay, perfect.
Yes.
And Barton, what do you do when you're not in court or otherwise?
Well, my free time these days is dominated by my 2 little girls who are 4 and almost 2.
Wow.
So nice. that keeps me and my wife quite busy.
I would imagine so.
That's a flashback with the girls you have in your family.
Yeah. Those days, I remember those days.
I remember those days, too.
I remember those days.
It's fun, especially in the fall. My wife and I have competing allegiances. She's a Georgia fan. I'm a Georgia Tech fan. So we are trying to persuade our daughters to choose each of our teams these days.
You'll get one.
I think I'll get the younger one.
All right, folks. Well, we're coming to a close of another episode of Atlanta Legal Experts. We want to thank our guests for being here. Craig, enjoyed the show, having you in the studio.
It's great being here. Great being here. And still can't get over the gray. They got it down. Right, yeah. Go to Pro Business Channel, folks. You got to see this.
You got to check out the photos. And again, thanking our sponsors, Peachtree Offices, 3A Law Practice Management, and Atlanta's John Marshall Law School. On behalf of Emily Rowell, Rich Casanova, and Craig Williams, we'll see you next time on Atlanta Legal Experts Radio.
Thank you so much.
Absolutely.
Thank you.
Mm-hmm.
Thank you again for joining Emily Rowell and her guests on the Pro Business Channel. Use the social media links here to share today's show and stay tuned for the next episode of Atlanta Legal Experts Radio.